begin the last panel discussion, and I think it's very hard, I think all of them are very interesting, but I think this one is particularly interesting given some of the important issues that it touches on with regards to the SDGs and sustainable development. We are thrilled to have Mr. Luigi Di Chiara from the Department of International Cooperation here at the Foreign Ministry presiding this session. So, Gigi, thank you.
Thank you. Thank you very much, Judith, Excellencies, distinguished delegates, ladies and gentlemen. I hope you had a chance of drinking a good Italian espresso, considering that it's almost 5 o'clock and we had a pretty long but interesting day of work. It was indeed interesting. With great interest, I listened to the keynote speech by Fabrizio Hochschild, the Assistant Secretary General for Strategic Coordination. And I became even more convinced that when we speak about rule of law, we immediately think in terms of peace and security, institution building, human rights protection. But as a matter of fact, rule of law and effective legal frameworks have a fundamental importance also when it comes to economic activity. Our session today will be devoted to reflect upon how effective legal frameworks can help spur economic growth and the generation of prosperity everywhere, but with a special focus on the least developed countries and those who are left behind. As I was saying, rule of law has a lot to do with economic activity and has a deep influence on decision by the private sector. You know that with the adoption of the 2030 Agenda for Sustainable Development and with the Addis Ababa Action Agenda on Financing for Development, there has been a re-evaluation of the role of the private sector, which is quite central in fostering sustainable development. I think that everybody agrees that there is a positive correlation between rule of law, effective legal frameworks, and economic growth. I did some light research on the internet because I'm not a lawyer, and I've seen that there is a widespread agreement on the fact that there are a few factors that confirm this positive correlation. These few factors are protection of property rights, effective government and political accountability, which means basically no corruption, proper legislation and enforcement, especially business regulation that must be clear and must be enforced in a transparent manner, and repression of violence. These are, according to international practice and to international studies, we can call it the rules of the game for rule of law and economic activity. When these rules are in place, there is more economic growth. When these rules are not in place, there is less economic growth. But I think that apart from the factor that I've mentioned, there are also other important features of this relation that allow us to think in terms of strengthening rule of law with a specific look at increasing chances of having a more inclusive economic development, and to give opportunities to those that, to those persons, to those companies, or to those countries where the economic climate is not so favorable to enjoy from the benefit of globalization and economic growth. I would like I was planning to briefly refer to a program that Italy funded with IDLO, and that had a very successful presentation last September in a side event to the General Assembly in New York. But maybe later on I'll ask, for the sake of time, I'll ask the Director General to briefly tell something about it. Now, with the help of our very distinguished panelists and the interaction with the audience, I hope that we will get some innovative or just informative inputs in order to, think in innovative ways in terms of elaborating programs and projects in the field of rule of law and economic growth. If you agree, I would like to have a first round of presentation by all panelists, and then I'll open the floor for questions from the audience. So without further ado, let me start by asking His Excellency Ambassador Sani Mohammed, who is the rector of the African Institute of International Law, to tell us something about the activity of the Institute, and to specifically focus on problems and issues that African countries experience in especially attracting foreign direct investment. Africa, Sub-Saharan Africa, now is the region of the world where 35 out of 45 least developed countries are located. My Prime Minister Gentiloni, was yesterday in Angola, today in Accra, and tomorrow we will be participating in the EU-Africa Summit taking place in Abidjan. I was checking news from his visit before, and it seems that all requests coming from African partners are in terms of exporting our small and medium enterprise and our private sector system rather than our development cooperation. Ambassador, you have the floor.
Thank you very much, Mr. Chairman. I titled my presentation as Capacity Building Contribution on the Creation of a Sound Investment Climate to Sustain Africa's Economic Development. In this millennium, international law, the law of African Union, and other regional organizations are to be understood and used for the development of African countries. Indeed, one of the challenges facing Africa is to develop the capacity to sustain growth at the required levels in order to reduce poverty and promote sustainable development. After decades of political, social, and economic difficulties, the African continent is experiencing a period of relative peace and economic growth. Current projections indicate better prospects for growth in the near future. However, a deficit of capacity at all levels undermines the continent's ability to sustain and maintain these positive trends. The ineffectiveness of relations between states, regions, institutions, and individuals continue to exacerbate development challenges Africa faces. These constraints relate specifically to the leadership and management methods, response system and mechanism, information and communication system, and deficiencies in skills and knowledge. Other challenges are related to optimal allocations and use of resources, both human and financial, and the absence of culture of accountability and responsibility. This has not only affected the level of professionalism, but has also had the consequence of low impact in terms of development. It has emerged from the participatory process that in Africa, the objective of capacity development are often not systematically considered or integrated in national, regional, or sectoral contexts. Moreover, despite the reality that investing in facilitation and front-end community development pays huge dividends, governments are often hesitant to fund capacity building initiatives. In addition, there is not yet any sufficient guidance on capacity development modalities. As governance mechanisms and capabilities vary from one African country to another, it is imperative to involve the perceptions of stakeholders in the public and private sectors, such that the capacity building activity could be an all-out social mobilization to promote effectiveness. The institutionalization of said visions of framework is essential for productive dialogue on capacity development as a means to achieve development and as a dynamic change. As an agenda for change, capacity development requires, in essence, a common definition, understanding of the key aspects and processes, born of active participation of many stakeholders in the definition of new social order centered on the citizens. It is for this reason that the African Institute of International Law was established, among other things, initiate programs meant for the development of state capacity and institutions based on multi-stakeholder participation that is characterized by shared responsibility and a vision of development results achieved through concerted effort. This view came at the right time as it is based on NEPAD and an African Union program where strengthening state capacity is a crucial aspect of creating an enabling environment for the development and implementation of programs of poverty reduction. The Institute is dedicated to the teaching, dissemination, and advanced research in international law, the law of the African Union, and other regional organizations. One of its basic objectives is to remove asymmetric technical capacities and level the field of legal expertise between African states and their foreign partners so that African countries can more effectively participate in a globalizing world and derive more benefits from trade, foreign investment, and the exploitation of their natural resources. This is to be achieved through capacity building by the African Institute of International Law. The Institute creation was premised on the fact that many governments are not able to play the capacity building role, and the work we have done so far convinces us that the benefits of capacity development can help to strengthen good governance in all its ramifications, a consideration claiming to be essentially normative in that it identifies such norms as transparency and achieving results through systems and processes. Capacity building is thus essential to achieving governance objectives and several sectoral targets. Rules and effective management systems, which are important outcomes of capacity development, are likely to further strengthen accountability and transparency, which are governance objectives. Reform should also build on existing structures through simplification, rationalization, and better performance management. Mr. Chairman, overall, the consequences for this capacity development is the creation of an environment and climate conducive to reciprocal encouragement, promotion and protection of investment. Government officials who wish to improve their bargaining powers and get better returns for their country resources must develop expertise on the preparation, development, and implementation of investment treaties and contracts, as well as on conflict resolution. The recent financial and economic crisis has demonstrated that national and regional economies are intimately connected with the global economy through trade, investment, and delivery of services. Therefore, policies and agreements that regulate trade and investment have a great impact on the economic and social development of the respective countries. A better knowledge of the standard terms and conditions of bilateral investment treaty will enable government officials to increase the continent capacity to benefit from external trade and investment opportunity. The Institute considers that lack of stable government and predictable legal system will cause foreign trade and investors to head to a more secure markets, and economic progress in Africa will be stagnated. In this regard, the Institute training program are designed for lawyers and government officials working in the field of international trade and investment law, particularly those in the Ministries of Finance, Trade and Investment, and Foreign Affairs, and those engaged in multilateral and bilateral negotiation, as well as other official and policy makers, members of legal profession, private legal practitioners, lawyers in the Attorney General's chambers, staff of the legal departments in public and private corporations, legal secretary, legal advisors, and arbitrators in the public and private sectors, legal scholars and practitioners, and judges. Finally, Mr. Chairman, it is important to both secure environment for foreign investment and the enforcement of arbitral decisions on state investor or commercial disputes require an independent but also a highly skilled judiciary which understands issues arising from foreign investment. In addition to the training of government officials and functionaries, IDLO and IIL can work together in upgrading and improving the skills of the judiciary, particularly high court judges in the area of investment and dispute resolution on commercial and business matters. In conclusion, there is the need for capacity building in the LDCs, the majority of which are in Africa, to benefit from foreign investment, which they need most urgently, especially considering the growing foreign investment in Africa and how it will soon generate disputes. And unless these disputes are properly settled, foreign investment will flee African countries. Thus, the grounds need to be prepared, and government officials, legal practitioners, and the judiciary all need training and capacity building and constant updating. Thank you very much, Mr. Chairman.
Thank you very much, Ambassador. Thank you very much for illustrating the range of issues that needs to be fixed and related to capacity development that is needed in order to improve the investment climate in African countries and in general the overall governance. Many of the items that you have touched upon are part of this program of IDLO that we presented in New York, on which I will come back again later on. But let me now turn to our president, Mr. Nawaf Al-Mahamel, legal advisor of the Kuwait Fund for Arab Economic Development. Mr. President, the Arab Fund is a well-established institution that is operating since long now, and I suppose you have matured an experience in, especially in dealing with rule of law in a special context of Arab countries. We are eager to learn from your experience. You have the floor.
Thank you, Mr. Luigi, for this introduction. If I may say, unlike what the name might indicate, that's Kuwait Fund for Economic Development, or for Arab Economic Developments, someone might think that it's work only in Arab countries, as the name indicates. But this is the case when it was established in 1961. 1971, it expanded to all developing countries, but the name kept as is for historical reason. And today we have an operations in more than 106 countries around the world, mostly, of course, all LDCs, lower developing country, plus middle income countries. I would start with what Ms. Najat bin Saleh said. All ingredients are important in her speech today. And we believe that the entire 17 SDG are important to the rule of law and to the development as a whole. In Kuwait Fund, as a development aid agency, we directly work on 12 out of the 17 SDGs on a direct involvement. The rule of law, we tackle it in two aspects. The first one, indirectly through the projects, and the second aspect is through partners that we work on, especially IDLO. The first one starts from the cycle of the project. When we receive an application for financing in a development project, it has to be supported by a socio-economic feasibility study. We intensively study this feasibility to ensure that it is technically viable, that it lead to the development of the economy of the country, and if it is has a financial aspect, it is scientifically measured through calculating the internal rate of return to ensure that this project positively will contribute to the economy and not as election-driven or a white elephant issue project type. That is the first aspect. Then through the cycle of the implementation of the project, we became or we become a partner into the implementation of the project. We participate on the procurement of the consultant. We review the contract with the consultants, and whenever it's signed, it is deposited copy of the contract with us, and payment through this project goes directly to the consultants based on the government requests as the project progress. The same methodology is used also with the contractors. We participate on the shortlisting exercise, on the pre-qualification, or any procurement method that is used to finance the project. We believe being partner of this process contribute to the transparency of these projects. Sometimes we receive complaint from some of the consultants or the contractors who were not awarded the projects, raising issues with us. Thus, we go and investigate these issues to the benefit of the project and the country that is also involved. We also involve in certain developments, for example, what is happening for the refugees. As mentioned earlier today, that the effect of the refugees crisis, especially in the Syrian situation, have casted its shadow on all over the region and also into Europe. Our intervention was targeting certain segment of the refugees, the one in host communities, not the ones in the camps. And in those intervention, we worked with host countries, with host communities to deliver the services on two subsectors, the health and the education, which turns back to the first and second goals of the SDGs, which having access to education and access to health services. We believe these basic services is required to the advancement of rule of law. This is the first part that I mentioned to you, that is the indirect involvement. The second part, which is the direct involvement, which is used through the partner of choice. IDLO has been a partner with Kuwait, and especially with Kuwait Fund for Economic Development, for a little over 30 years. And we together delivered several projects in the region for capacity buildings, for lawyers also in developing countries and lawyer into middle income country, to projects to advance access to justice. And we're currently also working with them to develop a project targeting women and children segment of the refugees for their rights. That is in cooperation with our colleagues in Turkey, which will be the targeted place for the refugees in that country. So that is the intervention that we do. Of course, it is inherited characteristic of a bilateral funding agency not to be widely focused, similar to international agency in all area. We rather pretty much brick and mortar funding agency focusing on the infrastructure, and whenever there is a direct involvement in rule of law, it is usually done through a partner organization like IDLO. And thank you.
Well, thank you very much, Mr. President. I totally share your point of view on the need of investing more in refugee communities that nowadays risk spending a lot of time in a condition of transition where it's not only required to provide shelter and food, but also all sorts of other services in order not to have a lost generation. It's quite interesting the wide range of activity, also geographically speaking, of the Kuwait Fund that is now among the leading financial institutions participating in the endeavor of implementing the 2030 agenda. I would like now to give the floor to Mr. Xi Wei, Director of the Department of Treaty and Law from the Ministry of Commerce of China, for listening his reflection on the linkage between the rule of law and economic growth. I mean, China has gone through probably the most terrific process of economic development, has become a leading nation, especially in the implementation of the Agenda 2030. Last year, presidency of the group of 20 has really represented a strong push forward in the implementation of the Agenda 2030. China has recently launched the project of the One Belt, One Road initiative. Please, Mr. Wei, tell us if you have any plans on linking rule of law with economic activity in such a huge activity of fostering economic development. You have the floor.
Thank you for your kind introduction. China has experienced a lot reform and opening up policy. We set up the policy reform since 1978, and it's already nearly 40 years. And from our own experience, we draw a very important lesson that the rule of law is a very important factor for the economic development, because during the process we often met the problem how to balance stability and development. And after many trials, and we found that rule of law is very important, such as respect contract and protect property and fight corruption. All these factors will make great contribution both to stability and development. Nowadays, China talk about a lot about One Belt and One Road initiative. When we're talking about One Belt and One Road, we are talking about to facilitate trade and investment along the Belt and Road, and we talking about improve the business environment, and we are talking about common development. And all in all, we believe that the rule of law is a very important factor for these objectives. And China is willing to cooperate with IDLO and relevant countries along the Belt and Road. We will cooperate to bear in mind that our cooperation should be based on mutual discuss, mutual construction, and mutual benefit. And we will try to provide more public goods for the construction of the One Belt and One Road, and to serve the needs of the government and the business. And we believe through this kind of cooperation, we could to make contribution to the sustainable and inclusive development for the participating countries. Thank you.
Thank you very much, Mr. Wei, for telling us how China is planning, starting from his own development experience, to improve business environment along in the regions that will be included in the project of One Belt and One Road. And thank you also for the future, the perspective of future collaboration with IDLO. Certainly an important partner of the organization. I would like now to turn to my right to Ms. Marianne Birken, which is General Counsel of the European Bank for Reconstruction and Development. The bank has quite an important activity, is expanding the geographical scope of its intervention. In your capacity as a General Counsel, I think you are very well positioned to tell us what is your the view of the bank on the linkage between rule of law and economic development.
Thank you very much, Mr. Chair, Mr. President, Director General Khan. Thank you very much for inviting me here today and giving me this opportunity to talk a little bit about what EBRD does when it comes to helping our countries of operation sort of reform their legal and policy environments. We started our legal reform program already in the 1990s. And we call it our Legal Transition Program. As you all may remember, the bank was established to foster transition in the centrally led countries of the former Soviet Union and to become market economies. And already at that time, in the 90s, we advocated this concept of good laws make good economies. And that is now, as everyone has said, really proven still to be very, very true. EBRD is a large private sector investor in the countries in which we operate, and our legal reform work really complements those operations through supporting the investment climate of the countries in which we operate. So our legal and policy reform work is really focusing on investment climate. Through our operations, we're also aware of legal gaps that exist. And it's our diagnostics that inform what we will do in a country when it comes to either our investment program or our policy dialogue. And so based on our diagnostic, we will have a country strategy with a very focused set of targets when it comes to what we need to do in that country. In the first area in the 1990s that we identified was secure transactions, creating investor-friendly frameworks for lenders and really based on international best practice. Later, we expanded our program to include corporate governance, insolvency, concessions, PPPs, telecoms, public procurement, energy efficiency, climate change. But as I said, it really is all targeted on the investment climate. And in all these areas, we do standard setting. We also do national assessments, so we're looking at sort of state and play in the country. And we also provide technical assistance. And the justice sector reform is one area where I think we traditionally have had a lot of involvement. When, in particular, as we've all learned, good laws on the books are just one thing, but it is critical, and we heard this from other speakers as well, that laws are implemented and enforced. And in particular, there is really a clear correlation between the lack of clarity and predictability of a legal system and an enforcement system and the investment in a particular country. This has, I was in Asia during the financial crisis, and after the work that we did after that sort of occurred is really very clear as well. The laws actually were not the problem. A lot of countries had, during their development phases, adopted very good law, but it really was the enforcement of the laws that were lagging behind. Around 2006, we teamed up with the IDLO, which has a very deep expertise in working with the justice sector. And so we worked first on the project in Kyrgyzstan, then expanded to Tajikistan, Mongolia, Tunisia, Montenegro, Egypt, Ukraine. So we really have a very deep relationship. It was mentioned this morning a few times. We signed a framework agreement earlier this year, which really strengthens our partnership. And in particular, as we are developing more work in new geographies where we are operating. So it was another sort of point made, I think, by the chair. We did, in fact, we have expanded our region since we were established in 1991. And in particular, in 2012, and this came out of the Arab Spring, originated the idea that the bank should also operate in the MENA region. So we were given the mandate to work in Tunisia, Morocco, Egypt, Jordan, and since last year also West Bank and Gaza, and recently Lebanon joined as a member as well. So that gave us very interesting challenges because it is a completely different environment from what we were used to. We were used to working in a region where there was really a clear and enthusiastic sort of commitment to reform. We started really with a clean slate, and we were sort of the transition experts at the time. When it comes to the new regime, the MENA region, is a very different environment. So these countries have had market economies for decades. They have long legal histories. They have often based French legal systems based on French law, and also long-standing relationships with other IFIs like the World Bank, African Development Bank. So it has taken us a little while to develop our technical assistance activities in that region, but now we are really sort of picking up speed and also working quite actively in that region, including doing training of the judiciary. We did the project with IDLO in Jordan. We're also working on a project on gender with women entrepreneurs and women judges in Jordan and Egypt. And we are in fact working on a Women Judges Forum in Morocco next month. And hopefully, actually, I hope everyone comes to the gender session tomorrow when we will hopefully have some interesting discussions about the work we're doing in gender. So we are really seeing there's still a lot of work to be done. And we are very grateful that we had the opportunity to team up with IDLO and looking forward to more cooperation.
Thank you very much, Ms. Birken. Justice sector reform and training the judiciary go hand in hand with trying to foster economic development in partner countries. Partnership with IDLO, it seems it's working very well. It's an example to be followed by other institutions. I would like now to ask Dr. Toledo, who is a legal counsel and a representative in Mauritius of the Permanent Court of Arbitration, to tell us something about international dispute resolution mechanism. It's an important part of especially for foreign investors when it comes to the effectiveness of the legal frameworks of foreign countries in which they are investing them. I understand it's also quite a burden, especially for least developed countries, to afford this kind of process in case of conflict and litigation. Dr. Toledo, you have the floor.
Thank you very much, Mr. Chairman, Your Excellencies, fellow panelists. It's a privilege to be here and address you today. Just by way of introduction, I'd like to introduce my organization. So the Permanent Court of Arbitration is an intergovernmental organization established by treaty in 1899. The PCA is not a court in the strict sense. Rather, we are an institution that is permanently available to states willing to settle their disputes peacefully by means of arbitration, but other forms of international dispute settlement, such as mediation, conciliation, and so on. Initially, we were established to provide services to states only, but with time, the PCA also expanded its scope, its mandate, and today the PCA also provides services to not only disputes involving states, but also those involving state-owned enterprises, international organizations, and private parties. At the moment, the PCA has 121 contracting parties and is currently administering nearly 130 disputes. Just a fraction, as you can imagine, are disputes between states, arbitration between states. As a result of these long years and, of course, the many cases in which the PCA has been providing administrative support, the PCA has developed a unique experience with matters related to arbitration, but also conciliation and mediation. And as a result, the PCA has engaged with its contracting parties also in matters related to capacity building projects involving international dispute settlement or alternative means of dispute settlement. And why? Countries, they have contracting parties, but also the international community has been focused on alternative means of dispute settlement, such as arbitration, mediation, and conciliation, and why the PCA has been part of this project as well. First of all, there is an argument that alternative means of dispute resolution, they improve access to justice. So in many jurisdictions, we see that domestic courts sometimes, as they say, are flooded with cases, or they have a lengthy, let's say, timeline to settle their disputes and to render a judgment. So sometimes having an alternative and recognized mean of dispute resolution can also allow individuals to seek justice and settle their disputes, especially those that can be arbitrated or subject to mediation and conciliation. There's a second argument related to economic development. Arbitration, for example, let's say the level of maturity related to arbitration has been an index under the ease of doing business of the World Bank. So it has been a matter of great concern for countries to also develop its arbitration regime locally, domestically, as a means to attract foreign investment and so on. And why exactly arbitration can help economic development? Usually matters related to enforcement of contracts. Again, the fact that in many jurisdictions sometimes it's difficult to have a contract enforced, or having a contract enforced after 10, 15 years. Some say that arbitration can be an useful and effective alternative to, let's say, the usual ways. And also, in some ways, institution building. A mature arbitration regime domestically can also in some way means that the judiciary of this country is somehow better positioned to assist parties in delivering justice and somehow supporting arbitration. So how the Permanent Court of Arbitration has been part of this development and capacity building projects. So far we have been acting on an ad hoc basis, so have been engaging directly for contracting parties, basically for tailor-made projects. But there are basically two ways in which we have been assisting our contracting parties, and the same contracting parties they have seen as the main ways that it can be helped with in matters related to the development of arbitration, again, domestically speaking. The first one concerns the draft of arbitration laws. So usually we provide comments to the draft legislation. And secondly, training and capacity building initiatives. There are two ways here in which we see there is great opportunity and also great opportunity for further cooperation and those capacity building initiatives. One related to the judiciary. Often we have worked with judges of local courts, of domestic courts, in ways to share knowledge and expertise on best practices involving arbitration and international arbitration, but also working together with the governments and usually Attorney General's office in matters related to international arbitration and those of investments and so on. Mr. Chairman, I stop here, but I'll be glad to answer some questions later. Thank you.
Thank you very much. I personally, also out of my personal experience abroad, think that sometimes developing countries have ideological problems when it comes to protection of foreign investments and the international machinery for settling disputes. But it is true that they need assistance in order to have a fair approach to this kind of mechanism. I would like now to call on Ms. Josephine Stubbs, who is a long-serving multilateral officer. Her career culminated in being Vice President of IFAD. She recently joined the Enel Foundation. Enel is an Italian company active in the energy sector, especially renewables. I'm also sad that we should celebrate your intervention because it's the first time that a representative of the private sector addresses the assembly from this side of the podium. Josephina, the floor is yours.
Thank you, Mr. Chairman, and thank you to Dr. Khan for this kind invitation, which we have just jumped in, because we believe, as it was discussed in New York for the SDGs, that the private sector has a central role to play, together with governments and the international community, to help the world achieve the Agenda 2030. If many of you, I'm sure, were there when the discussion took place, and the estimations in Addis Ababa were of $1 trillion minimum for investment to achieve the SDG. No single government, no single company, no single multilateral agency has enough money to really put it together to achieve the SDGs. So I mean, this is as the first time that we participate in this dialogue. I think that first of all, we came here to learn and to listen to you. We are not lawyers, but we have a commitment to really create shared value, but also for us to see how we can, we as an institution, as a multinational working on energy, to really see how we can create much more value to and share the creation of value to more communities. Let me just say that NL and NL Foundation, we understand that energy is absolutely essential for human development. It has to do with poverty reduction, it has to do with gender, it has to do with health. It really cuts across the entire SDG objectives, and I mean, it weaves all of them to really make it possible. We don't know, I don't know, I have never seen a country that can develop without energy. And even though since the year 2000, a lot of progress has been made in the issue of access to energy, we still have 1.2 billion people without access to electricity. Most of them, 43% of them, in the sub-Saharan Africa region. And of those who are without electricity today, which is 43%, most of the people are in the rural sector. Italy and Rome are the basis of the agencies working on food security, working on creating employment and creating productivity in the rural sector. Energy is absolutely essential for the SDG, not only because everybody should have access to energy as a basic right issue, basically, but also because productivity in the rural sector and poverty reduction, which is pushing people away from the rural sector, is absolutely essential. We have seen that there are 2 or 3 areas in which NL would like to learn, I mean, even more. One, as the chairman rightly said, is not only about money, and we all know that there is a need for money, but it's not only about money. It's about the transfer of technology, and it is capacity building. Last week, the World Bank published a report in which they said that 53% of the projects of the World Bank on energy sector in Africa are considered moderately satisfactory or less. In part because the capacity of the institutions, not only to create the regulations, but to implement them on the ground on a day-to-day basis is still work in progress. So the transfer of technology and capacities for institutions is absolutely essential, from procurement to coordination. The second area in which we believe that a lot of work needs to be done is still in the area of coordination and transparency. We see that there is an important diversification of sources of energy, with renewables going much more important at different levels, at the local level, at the national level, but there is no coordination yet, which means that a lot of resources are not being really used to its maximum. There are examples in Bangladesh, there are boards that have been created in Tanzania and Kenya, which can really help coordinate, but also ensure that transparency and regulations are really working for everybody, for the private sector, for the government, but also for consumers. I think there is also one issue which we would like to look at in the future, which is the issue of the regulations of small and medium enterprises, which are absolutely fundamental in all developing countries, so that we can help open markets and discussions with governments as to how to offer opportunity of SMEs at the local level to be part of the decentralization of offering services, be they energy or any other type. When we talk about access to energy and energy poverty, it is true that it's mostly in developing countries, but we have seen, and this is the last report of the International Energy Agency, which is telling that also in developed countries, there are issues of lack of access or enough access to electricity of sectors which are very poor. The experience of creating incentives and programs to make sure that everybody has access to the minimum amount of energy that they need to be considered included, I think is something that we are also looking at. NL has a commitment to create shared value. And in doing that, the idea is that sustainability has to be built in closing the gap of inequality. and increasing access to services by everybody. And it doesn't matter where it is, the intention is to sort of expand the capability of people to have access. I cannot close without talking about women. When we talk about energy, we talk about the household, but we also talk about the enterprises, most of which are managed by women. Moving the discussion from electricity to include clean cooking will make an enormous difference to millions of women who are using still biomass, charcoal, and other sources of energy, affecting their health and the health of their family. Of course, I mean, as a spin-off effect, you also have a better management of natural resources and less hours by children and women spent in collecting fuel and wood. So I leave it there. I know it's a little bit too much information, but we can come back later. Thank you, Mr. Chairman.
Thank you very much, Ms. Stubbs. Thank you very much for telling us from, let's say, the other side of what energy companies need to in order to invest, but also what they, especially in the case of such a global leader like Enel, what they can do in order to foster development in the sector of energy, which is really a strategic one if we want that development be also sustainable. Before moving to the question and answer part of this session, I would like to call on the floor Erwin van der Brood, Director, Department of Programs of IDLO, to tell us in pills what the program of assistance by IDLO on least developed countries in attracting foreign direct investment is about. Erwin, you have the floor.
Yeah, good evening, and thank you very much for allowing me for a few minutes to provide a bit more explanation. I think throughout the day there have been various references to this investment support program for least developed countries. It's an initiative which IDLO has helped designing with the UN Office of the High Representative for Least Developed Countries in New York over the last 12 months, and it was formally presented and launched at the end of September in New York during the UN General Assembly sessions. It's also important to see the launch of this program of work in the context of the Program of Action for Least Developed Countries, the 10-year Program of Action, and also, of course, in the context of Agenda 2030, specifically Sustainable Development Goal 10, and then one of the targets under Goal 10, which recognized the importance of foreign direct investment for least developed countries. So the aim of the program is to provide support to least developed countries in their negotiations and concluding of investment agreements, bilaterally or multilaterally, including, of course, with the private sector. And by providing that support, we would facilitate legal and other expertise to those countries. We would also seek to support them if disputes arise out of those investment agreements, to help them navigate those disputes, including, for example, through international arbitration, and the importance of that has also been highlighted in the panel just earlier. We aim to be very client-oriented, that in essence we would expect and encourage least developed countries to call on the investment support program, so it would be very demand-driven, responding to their specific requests, and then we would tailor the support along those lines. And the unique aspect of the program is also that we are partnering up with a number of with the private sector, and then specifically with a number of large firms, legal firms primarily, who would make that expertise available on a pro bono basis or reduced rate basis. So I think that's also important, and was reference as well to the importance of partnering up between the public and the private sector, and I think this program is a very concrete and important example of that initiative. I would also like to highlight that, of course, the design stage was supported by Italy to the UN office. We are also very pleased that during the launch at the end of September, the European Union also pledged their financial support to the program. And we are also in discussion with potential other donors to financially contribute to the program, but in a way also politically, which is also very important. And then maybe lastly, I would also like to highlight that we are currently sort of piloting the investment support program. We have had initial small support program in Myanmar to provide capacity building to relevant legal officers in Myanmar around trade and investment agreements, because the support program will also have a very important capacity development and capacity building component. And we're also looking at a request we received from Senegal for specific assistance, and that is something we will follow up in December with an initial assessment mission to define the specific pilot intervention. So we're very pleased about the fact that this program is coming together, and the fact that IDLO can play a role there in essence managing the support program. I believe you have all received just before this session more detailed information about the program. So if there are any other questions or comments, we are always available as IDLO to respond to those as well. Thank you.
Thank you very much, Director, and thank you very much. Let me also personally thank the European Union for the support to this pilot project. This is, I personally think that this is one example of how we can think in innovative ways in terms of combining rule of law, development cooperation, and sustainable development without leaving no one behind. Distinguished delegates, we have 5 minutes for at least a couple of questions and a couple of answers. I open the floor. I see the European Commission. You have the floor.
Sorry. Thank you very much. And let me say the EC is very happy to participate in this partnership forum today. IDLO advocacy for the rule of law in support of inclusive development is a goal the EU shares fully. And given the short time, I won't develop further, but I would like to just say a couple of things about the fact that Agenda 2030, of course, offers a general framework under which we all have committed to a number of goals. The EU has developed, together with its own member states, a document which we call the European Consensus on Development, which is our way to start implementing the goals together with the member states, European institutions and our member states, in a coordinated, common way with a sort of guidelines for our action, which is, of course, then developed at the national level, but also as Europeans. And in this European Consensus on Development, there are at least 2 things relevant for today's discussion. One is the importance we give to the rule of law for creating and confirming the conditions for stability and peaceful and sustainable and inclusive development. And then also the focus on the least developed countries. So here we come to our program that you just described. Indeed, as you mentioned, the European Commission is happy to contribute to this program for investment support, because we believe that this is one of the conditions which can create the conducive environment to further private sector investment into developing countries, into fragile, least developed countries in this case, into fragile situations into those countries and situations where basically the private sector would not otherwise feel comfortable going. We have other ways, other programs as well as European institutions where we try to leverage through guarantees and other formats more investment from the private sector into fragile countries. But in this case, we found a very good project and we are happy to support it with IDLO. And so we wish success to this initiative, and we hope that it will be activated, so to speak, so we can test it and improve it as we go. Thank you.
Thank you very much, and attract other donors to this initiative. Thank you very much, European Commission. Mozambique, you have the floor.
Thank you, Chair. I'll be very quick. I just wanted to thank the panelists. We have learned a lot today. I just wanted to also thank for this program for the LDCs. And as the director said, that is program director said that is country demanding. I thought he's going to speak about Mozambique. He spoke about Senegal and others, but Mozambique is there on the list. Especially, Chair, because today we are faced in Mozambique with a lot of challenges, especially for negotiating the contracts, especially for the gas and the other minerals. So definitely we need the help of IDLO, and that's why I wanted to thank the Italian government, the European Union, other donors for this program. I think I will speak with my writer for the African Institute for International Law. I think there is a lot of information I would like to hear from him. The foundation, NL Foundation, because of energy, I cannot agree more with Josephine about that. That is very important to have access. All the population have access to energy. Thank you very much.
Thank you very much, Mozambique. I hope it's not Italian companies who are giving you a hard time because it's a country which is closely observed by Italian companies. We have time for one more comment or question. I see Jordan.
Thank you, Mr. Chairman. I just finally would like to highlight the importance of SMEs in developing countries. In my own country, Jordan, 90% of the economic activities are run by small and medium-sized enterprises. And when we speak about foreign direct investment, this is a very important topic and very relevant to sustainable development, but also small and medium-sized enterprises are very important. And here I'm referring in particular to economic legislation reform when it comes to simplifying the regulatory frameworks for the small and medium-sized enterprises to be able to contribute further to economic growth in developing countries and also create jobs, especially in the Arab countries where, if you want, in figures, the latest Human Development Report, UN Human Development Report refers to 70% of the population of this region as being under 30-year old. Thank you so much.
Thank you very much. That suggests me to inform you that the day after tomorrow, in the framework of the Mediterranean dialogues, we are organizing a meeting on management and economic use of water in connection with youth and innovation, exactly starting from the basis that you just mentioned. I don't think there is time for any more comments. I'll briefly wrap up saying that it seems to me, well, thanking first of all our really excellent panelists. It seems to me that there is more than an opportunity to invest more in reflecting on the connection between rule of law and economic activity from the point of view of what IDLO can offer to partner countries. that I guess will be food for thought for next year forum, where maybe we should foresee to expand a little bit time available, because I've seen the interest that the two panels, and I'm sure also will be confirmed tomorrow, have raised, and so this is food for thought for IDLO next year parties assembly. Thank you very much, and thank you for your patience.
We have just a housekeeping announcement by Ms. Judith, please.
Thank you very much, Mr. President. Thank you very much, Mr. Di Chiara, for such an excellent moderation of what is a very rich topic, and thank you to all the panelists for what has given us a lot of food for thought. And I think we just need a lot more days, given the richness of all the topics that we always try to discuss. So just a couple of, one secretariat announcement from member parties, and that is because you may not see your emails today, but an email will go out to from the secretariat just confirming that we have 4 nominations for the standing committee elections that are due to take place tomorrow. We have the nomination from Kuwait, the nomination from Sudan, the nomination from Peru, and the nomination from Ecuador. So we just wanted to let you know of that. We have 3 seats and 4 nominations, and that will be the final item in the agenda tomorrow. And just in terms of housekeeping, we reconvene at 9:30. We ask everyone, obviously, to be on time, and more importantly, don't forget your badges, because your badges are needed to grant you access into the building for security. For those of you who have traveled from Capitol and are staying at the hotel, I understand that my colleague is going to wait for you outside of the cloakroom to be able to facilitate transfers back. And thank you very much. Hope you have a nice evening, and we look forward to fruitful discussions tomorrow.
Thank you, everybody. We look forward to seeing you tomorrow.